Yes, welcome to the No State Project live from the fortified compound here in Mesa, Arizona. And, I took care of all the things I needed to do except for one. So I'm going to have to do that like I've done before and see if I can get this done without alerting I'm making it too damn obvious. We got a lot of stuff to get to. I know we're expecting a lot of calls, which is part of my problem here. So if you bear with me for just a second, that's what was so nice about when I would do the show. And it is December 11th, 2019. When I did the show and I used to pull the live feed down after putting in some graphics. I could take stuff like this out, but I can only edit this stuff out of the podcast. And sometimes I don't even take the time. I don't have the time to do even that. But what I'm going to do is I'm going to get up to the caller line, and I'm going to get on there without even being able to hear it. But if you want to join me, it is 218-632-9399, 218-632-9399. Is that their passcode? That'll get you into the queue. Yeah, 2020 and the pound sign. I'm doing that now, so that's so I kind of actually remembered that. Thank goodness. But you can also reach me on Skype if you instant message me first. Let's see, did I do? Hey, I did it right over there. Yeah, I can do two things at once. Yes, 218-632-9399. I want to thank everyone for their continued support of the show, the No State Project. Definitely needed, definitely appreciated. Chris in California, Bill in New Hampshire, and Eyal in Israel, and Nelson in Maine, Don. I'm sorry, I should write them down because it's not too long a list. It's only a few names, but I always seem to. But and then there's Marc and who's probably freezing right now. I do appreciate all the continued support of the show. If you want to help support the show, it is markstevens.sells.com. That's sells with a Z, SELZ, markstevens.sells.com. And of course, my website, markstevens.net. And hey, if you're being attacked by a bureaucrat, you want to learn how to more effectively defend yourself against these baseless code violation things that they got their pensions riding on. Government Indicted is the book. It's got a full model on how to deal with these people. It has proven to that if you're using the principles in the book, you will be able to replicate the success that others have had and I have had. And the evidence for that, because we are all about the evidence over here, markstevens.net. Look under these success stories. I'm still waiting for someone, a more recent success story. I don't have that evidence yet, but I probably should just make a separate video for that because I have about at least five to seven success stories that I needed to get to since May. And I have not been able to do that, but I will do my best to get that. But you can see the replicated success at markstevens.net. Just holding your accuser to their burden of proof. So a couple things before we get to those phone calls when they start filing in. Someone asked me to read the definition of a 14th Amendment citizen from the slaughterhouse cases. So for those who weren't aware, the slaughterhouse cases were a bunch of consolidated cases that made it to the Supreme Court, and it was decided in 1873. And it held that the privileges or immunities clause of the 14th Amendment to the U.S. Constitution only protects the legal rights that are associated with federal citizenship, not those that pertain to state citizenship. The decision consolidated two similar cases. Seeking to improve sanitary conditions, the Louisiana legislature and the city of New Orleans had established a corporation charged with regulating the slaughterhouse industry. Members of the Butchers Benevolent Association challenged the constitutionality of the corporation, claiming that it violated the 14th Amendment. That amendment had been ratified in the aftermath of the American Civil War with the primary intention of protecting civil rights of millions of newly emancipated freedmen in the southern United States. But the Butchers argued that the amendment protected their right to sustain their lives through labor. In the majority opinion written by Associate Justice Samuel Freeman, kind of ironic, Samuel Freeman Miller, the court held to a narrower interpretation of the 14th Amendment that the plaintiffs urged, ruling that it did not restrict the police powers by Louisiana because the Privileges or Immunities Clause protected only those rights guaranteed by the United States, not by individual states. In effect, the clause was interpreted to convey limited protection pertinent to a small minority of rights, such as the right to seek federal office. In a dissenting opinion, Associate Justice Stephen J. Field wrote that Miller's opinion effectively rendered the Fourth Amendment a, quote, vain and idle enactment, end quote. Though the decision in the slaughterhouse cases minimized the impact of the Privileges or Immunities Clause on state law, the Supreme Court would later strike down state laws on the basis of other clauses in the 14th Amendment, including the Due Process Clause and the Equal Protection Clause. I guess they should have included due process in their argument there. So what somebody wanted me to do was they were under the impression, I heard this in a long time, that Justice Miller, Samuel Freeman Miller, actually defined 14th Amendment citizens as corporations. Now, with the benefit of technology, you can go through this and you can use the, what do you call that there? The search function. And you can use the search function for corporation. And I am not able to find anywhere in here where Justice Miller is defining a citizen as a corporation. So, you know, you just have to do a search for a corporation and just look at what's being said. It talks about the granting monopolies or exclusive privileges to individuals or corporations. But that's not saying that citizens or corporations. The next question to be determined in this case is a monopoly or exclusive right given to one person or corporation to the exclusion of others? Doesn't seem to be that he's defining a 14th Amendment citizen or 14th Amendment citizenship as a corporation. I'm not seeing that. I'm just not seeing it. That's that's what's so great about the search function. You don't have to read everything. Somebody claims that the Supreme Court said that, oh my gosh, the Supreme Court said statutes are not law. So all you got to do is go to the text of the document or the ruling there and just hit, I don't know, Control F or, the Apple F if you're on a Mac. Just do a search. And you can just type in statutes are not law. And you'll find out immediately that quote is absolutely not in there. So if you expand it, you'll find that the actual quote that they were cherry picking words, taking words out, was unconstitutional statutes are not law. No. I don't see it here. I've gone through it. I don't see it. I guess this is one of those things with the name in all caps makes, they're creating a corporation. I don't see where the Supreme Court is saying that. I don't. So I think it's wrong. I mean, all through this case, they're very clear. No other person or corporation should, by the consent of the Common Council. So I don't see it. So I'm going to have to go ahead and disagree with you there. That an associate justice of the Supreme Court is defining a 14th Amendment citizen, if that's really the right way to even say that, that were a citizen by virtue of the 14th Amendment, because of the Civil War and everything, is a corporation. And I think it just goes into this fallacious line of reasoning that, well, since that their government is an artificial entity, being a corporation, then it can only interface with other corporation. That's just ridiculous. So if somebody has an LLC, they can only do business and interact or interface with other LLCs. Patriot mythology that has yet to die a quick death. Maybe it's dying a slow death. We'll see. So, and if anybody thinks that that's in the document, what you do is you send me, put in the chat there some of the text. I can copy it. I can paste it directly into a search, and I'll see if it comes up. That is that the 14th Amendment citizen is defined as a corporation, not a natural person with the flesh and blood man or woman. Before I get to the calls, and it is 218-632-9399. The passcode is 2020 with the pound sign, or Skype is Frank Rizzo 3. Instant message me first. But I got to get this out. Hamilton County Sheriff's Deputy indicted on 44 criminal charges. It's actually 20. He's only indicted on 25 felonies because you don't indict for misdemeanors unless you're at the federal level. Couldn't happen to a nicer guy. Daniel Wilkey indicted on 44 criminal charges. This comes from timesfreepress.com. Let me put that you guys can watch in live, and damn it, you should be. You should be. Now you guys can see what I'm talking about. 25 felonies pertaining to incidents he was involved in while on duty in an official capacity, according to the Hamilton County Sheriff's Office. Wilkey, 26, has been at the center of a criminal investigation and at least 4 separate lawsuits involving traffic stops, during which he is accused of engaging in misconduct ranging from illegal drug searches. Shouldn't be drug searches, period, but illegal. See, yeah. I mean, they have so much latitude here, and even the prosecutor is thinking, wow, you stepped over the line. When you have a prosecutor who is saying that you are doing illegal drug searches, man, you have really crossed the line. Yeah, I know that he's committing the crimes on the job. That's that's the policy. I know. But I guess there's a limit. Apparently, there's a limit. And listen to what he did besides that. One of them, I'm bewildered by. Roadside body cavity search. Now, there are videos of police officers putting their hands and doing a body cavity search on women. Right there on the street. Forcibly entering in the genitalia area. I don't even know a forced baptism. Is that a nice way of saying waterboarded on the side of the street? And last but not least here, groping of female minors. Now, to be driving, well, then again, it didn't have to be a driver. It could have been a 13-year-old. I don't know. All we know is that he's been indicted for groping female minors. But he's been on paid administrative leave since July. And he's on a $25,000 bond. He's released on a $25,000 bond. There are people for nonviolent drug offenses that get more than $25,000. So they're definitely not treating him. It's good to be one of the king's useful idiots. You might get indicted, but you don't go to jail pending trial. And you get released easy on a $25,000 bond. Neil Pinkston, the Hamilton County District Attorney General, released dash cam footage of Wilkey and another deputy, Bobby Brewer, kicking, punching, and stripping the pants off a handcuffed black man. Gee, there's a shock. And you guys, if you go look, Wilkey is not black. He is a white guy. stripping the pants off a handcuffed black man on July 10th before allegedly performing allegedly, it's on video. You did say that there's body cam body cam footage of this. I can't talk over here. The level of criminality shuts things off. They performed a body cavity search on a side of a Saudi-Daisy Road. Wow. So it talks about the incident sparked outrage among Chattanooga's black leaders, with the NAACP characterizing the cavity search as aggravated rape and pleading for criminal accountability from law enforcement and unity from citizens in order to bring an end to police brutality against people of color. Wow. They were asking that Jim Hammond, the sheriff, should resign, but he won't. And he's not going to fire them, the deputies, without following the proper process. So the charges are, he actually has been, the 25 felonies. I'm not going to read them all because there's multiple counts of each, but there's a count of extortion. He's got something in common with Donald Trump. 2 counts of felony rape. He's got even more in common with Trump. Sexual battery. There's like 6 counts of that. Again, grab him by the crotch. Sexual battery. Official oppression. Reckless endangerment. Yeah. I can't imagine Trump supporters not going to bat for this guy. The misdemeanors are false imprisonment, assault, stalking, and reckless driving. Holy crap. Now, the thing here is, this guy is only in his mid-20s. He has had previous problems. Gee, there's a shock, right? A cop, a violent predator like this. Since he was hired in Hamilton County, he had 8 internal affairs cases opened against him. 8. But before he was hired on there, he was with the Rhea County Sheriff's Department. And it states here that Rhea County reached a settlement with a federal lawsuit that claimed Wilkey fatally shot Stephen Lee Buddy Howell while employed as a... So he's got a history of problems. So I would imagine that when you're looking at a list like this, that this is so over the top. This is so far beyond what the crimes that cops normally do. And maybe it had to do with the fact that he was sexually assaulting minors. Again, there's no indication of the age. If they were licensed drivers, then these were at least 15-year-old children. They could have been 17. That makes them a minor. Not necessarily a child, but I don't know. This guy is quite a predator. And this is just what they know. So, wow. 44 charges, including 25 felonies. Yeah. One of the county's finest, Hamilton County. Did I even say? Yeah, it's Tennessee, Hamilton County, Tennessee. One of Tennessee's finest. So I guess that's what you have to do as a cop to be charged in Tennessee. You have to have dozens of serious charges, felonies, including sexually assaulting minors, children. So, good job there, Daniel Wilkey. Wow. Of course, I don't doubt for a second there's going to be a whole lot of people like Trump-type supporters that are going to support him. People who think that cops can't do any wrong. It's a witch hunt. It's a Democratic coup. Yeah, it's a witch hunt. They're all lying. Every one of them is lying. They're out to get me. They didn't want me to be a cop. They just can't get over that I was hired. They've never been able to get over the fact that I was hired as a deputy. They hate that. It's a democratic coup. The libtards just can't stand the white man going and enforcing the law. All right. Whatever you got to do to get to sleep at night, right? All right. We're going to get to the calls. I'll get to some of the other things if we have time. But hey, at least that's a kudos. It's a big step in the right direction to hold one of these damn cops, accountable. Well, they just got to convict his sorry. And before someone says, well, come on, you haven't seen the evidence. I think the fact that, and it's been reported incredibly in a lot of, more than one, that they have dash cam footage of the assaults. Dash cam footage. And there are multiple people, more than 4 people have complained about this predator. And add to that the fact that a cop is charged at all. We already know from history, some good inductive reasoning here. We know from history, it's an extremely high bar for prosecutors to even entertain the idea of bringing charges against the cop. So for the average person who is sitting on the grand jury, the evidence would have to be overwhelming for a white police officer to be indicted. History is very clear on that. White police officers who are accused of crimes against black people, the bar is unfathomably high for them to be indicted. It's twice as high for them to even be convicted. So let's get to the phones. Again, we're going to dedicate the rest of the show, or if you got calls, we got the time here. So just please call back. We've got the caller line. We got Mac in Vancouver. Mac, welcome back to the show.
Hey, Mark, how's it going?
It's going well. How you doing today?
I'm doing not bad. Just taking care of some stuff. I was waiting for your show on Wednesday, and I don't know if you talked about it off the top of the show, but I guess you took the day off.
No, I'm doing the show right now. Today's Wednesday.
I meant, sorry, on Saturday. Maybe it was on Saturday.
Well, all right. Well, Saturday, let me explain. I'm glad you brought that up. That wasn't my fault. I know you use, well, let's use some inductive reasoning. Let's just look at I know that 99% of the time it's my fault. I get it. Whatever's going on here, it's bad. But I've had 5 shows now, or 6 shows, no tech issues. YouTube was down for live streaming for everybody. I don't know. Someone claimed home bumming it, said that they're shadow banning people. I don't see that. I'm doing the show right now, and Saturday was, if you can check the Wayback Machine or whatnot, that was a YouTube issue. No, I mean I couldn't even use my phone. So you could.
Oh wow.
Yeah, I couldn't use my phone to live stream. Everybody was down, so not my fault on that one. So, but yeah, not much I could do. I did speak to the guys, and we did a short role playing session with someone, and we talked about some things on the Skype chat, but yeah, we weren't able to do a show. But hey, we're good to go now. So what do we got?
Right on. Okay, well, I went back because time has flown by. Like, I can't believe I'm in December already. I got that Idaho appearance supposed to be next week, and I didn't deal with it. Life was pretty hectic. But I went back in here, found the call, one of the calls that I made. So I got it. It's on the 20th. I'm supposed to be there, but I'm going to file. I'm working on my motion for, what's it called? Oh, shit. My computer. What's the one? A motion. I'm going to file a motion in limine because I haven't got any of my disclosure or discovery requests. And motion for sanctions against the prosecution is what I'm working on as well. Now, the other thing is, you said you had some kind of a template or something where I could request to have it heard through Skype or phone or something like that, because there's no way I'm going to go down to Idaho for this. Now, how would I go about do that? Can I Skype message you to get that, or like, am I too close to the date? Like,
It is kind of
I'm
close.
in a bit of
I mean, if you're a week out, that is kind of close. Although setting things up, and here I am talking about this. That's ironic. It shouldn't be that difficult to set up to do have a speakerphone available. I mean, it is 2019, and they've had that technology for like 80 or more years. So it's worth a shot. I don't blame you. And for those who are listening overseas, who are not familiar, this is not the time to go to Idaho. I mean,
No.
anytime after September and before like June, unless you're a skier, not a good time to be in Idaho.
Yeah, I mean, it's 5 days before like the holidays is when they decide to move this date to, like, December 20th on a Friday. I mean, I meant to deal with it, but you know how life is. I just don't know where the last 3 months of my life went. It's just a blur.
My summer was pretty
I'm
bad.
under crunch.
Yeah.
Sorry?
My summer was bad. It's been the worst year of my life. The worst year. This has been the worst year of my life. And, I'm not going to discuss the details and waste time with that. I've already, people who regularly listen to the show know what happened this year. And it's, I understand. And we always tend to get busier these last 2 months of the year. So it happens. But I hate if you're not able to go and you can't get it continued or you can't get it telephonically. I hate, for you not to be able to appear and have it escalate.
Yeah, I mean, here in Canada, it doesn't turn criminal. They just find you guilty and put it on your driving record. To get your insurance or renew your driver's license, you just got to pay them. I don't know what the situation is down in the States because I do go down there, one or a couple of times a year. So what would they escalate this to? Would there be a warrant or?
Well, it's not criminal, right? It's just a civil infraction.
Speeding ticket, yeah.
Well, if you don't go, they're unlike in a criminal proceeding, they're just gonna rule against you, and you're gonna get a judgment. And if you don't pay it, then they will send notification to the Canadian authority to suspend your driver's license until you pay. I mean, you can always appeal it, but it's kind of tough when you haven't been able, you weren't able to show up, unless you can show valid grounds to excuse not going. So you could do it telephonically, try it telephonically, and say, look, if I can't do it telephonically, I'd like a continuance until it's more whenever so I'm better able to be able to make such a long trip down there.
Now, would this be one kind of like, what would I ask for? What would I file like for the telephonic hearing? Is that a motion or is just that a letter?
Well, it's a motion. Everything you do with the court really is by motion. That's just the language that, and how the process, we just call it a motion. And it's just a 1-page thing, really, most of the time when I do it anyway. And it's just laying out that it's not possible due to life circumstances. It's not possible to be able to travel down there for the appointed date. So, but you want to participate. You're not blowing off an alleged, responsibility. You're more than happy to do it telephonically. If it can't be done telephonically, then at least reset it to sometime at the end. Let's say, I'm just throwing this out, like, at the end of January, so that you're better able to make that trip. I mean, it's not like it's not like someone going from Burley to Idaho Falls. I mean, you're coming in from Canada.
Like 13-hour drive.
Holy crap! You're that. Wow.
Yeah, I'm up in Vancouver, Pacific Northwest. So I got to go all the way through Washington State, catch the corner of Oregon, and then all the way down to Twin Falls area. So, well, it's 12 and something hours, and of course, could be more, right? Like that's without any traffic and border waits.
Yeah, depending on the weather, it could certainly take you a lot longer. It could take 2 days, depending on the weather. I know
Exactly.
you guys just got hit back last few weeks ago. Now, there was a huge storm going through Idaho and Utah. So I had family drive down from Idaho that was just like in front of the storm.
Oh, they got lucky.
Yeah,
So,
yeah.
what is this? What would this be called? A motion for continuance, motion for telephonic hearing? Like, what would I call that?
I would say motion to participate telephonically, or any alternative for continuance. So depending on how they want to do it.
Okay. Or continuance. So I will get those in today. I mean, I have their emails, and the court had told me that I could file stuff by email to them and to the prosecutor.
Nice.
Now, what do I? Yeah. When I first sent my motion for discovery, I do believe in the email that I did say, can you please confirm that you received this? Otherwise, I'm going to keep resending it. Unfortunately, I didn't receive a response, and I totally forgot about it. Now, can they claim that they didn't get any of my motions? Like,
Well, yeah, of course. But when you're talking about a minor traffic like this, there's no pretrial discovery anyway. So they only have to respond the day of trial and give you what they're going to use against you, the day of the trial.
okay, so I don't understand that here. At least the what do you call them? The justice of the peace is up here. They make a big deal about this discovery disclosure request, and if I requested a month out, the officer needs to provide that to me within a couple of weeks. And if they don't dismiss the charge, but then they order an adjournment for me to review the documents. I mean, they do try to say, well, the officer will give you his discovery and his notes right now. Just go out in the hallway, look at it. And then I'll be like, well, this is unfair. I don't have time to prepare my defense, consult with a lawyer, etc. So then they'll grant an adjournment, but they do try to be like, say, well, no, it's only a speeding ticket. What do you need to prepare? It's either you did it or you didn't. You have a defense,
Yeah.
But they are more, they do like to, feel their authority on kind of making these kind of rulings that my rights, I have the right to prepare my defense. I don't remember the exact definition. So in the U.S., you're saying they don't care about that at all? Like they expect you to get the notes right before the trial and go in there and defend yourself without having a chance to prepare or let's say consult lawyers or legal advice, things like that?
Yeah, unfortunately, I can't point you to a particular court opinion on this.
Okay.
But they have ruled many times that the summary type proceedings in traffic, that they are. I know there was one where a lawyer here in Arizona 30 years ago, whatever it was, and he appealed the summary nature of like just what you're talking about, that you don't get discovery until immediately before the trial. And the appellate court said, well, that's been accepted as the process and as implied consent to these summary type proceedings because you got a driver's license. So, that was the reasoning in that particular case. It's probably a bit broader, when they say, look, that these are minor traffic. There's no jail time involved. It's not a sophisticated case. If it is one, they probably reason, I'm guessing here, they probably reason that because they so rarely involve very sophisticated, issues of evidence, that it's just like you mentioned with the comp saying, it's just traffic. It's it's not that big a deal. You don't have anybody but the police officer that you're typically going to question. So I would, if you have the opportunity, what I would do is I would say to the police officer, okay, since we're doing discovery kind of like right now, in addition to your notes, you are going to be, it is your testimony that I violated the law and that the laws apply and that I violated them. And he says, well, yeah, all right. Do you have personal knowledge of those matters that you're testifying to? I mean, do you have personal knowledge that the laws apply just because I'm fit? Yeah. And so that I would use that opportunity to ask him that. Now, if he's not able to give you that, now you've got facts to support your objection that the witness should not testify at all because he lacks personal knowledge of the matters.
Okay. Well, I think I'm dealing with the prosecutor for the Idaho one. In Canada, we always deal with the police officer, or in Vancouver, we do.
Well, you know for a fact, but you know for a fact that there's a prosecutor assigned? You have an actual name and bar number?
Yeah.
Oh, okay.
Michael J. Steve, Jerome County Prosecuting Attorney. Yeah.
Okay. Well, all right. You have to, well, but you still, if you had the opportunity where here, we don't know, if you have, you just ask the prosecutor the same question. So you're going to have the witness testify that the laws apply and I violated them, right? Oh, okay. And then you just ask him the same questions. Well, what facts do you have to prove that just because I was physically in Idaho that your Constitution applies? You ask him the same. He's the one that's responsible. He's the one that is going to be putting the witness on the stand ultimately. So he's the one that's responsible. Anybody who's going to rely on the witness has an obligation before they put them on the witness list and are going to make arguments based on their testimony and the evidence that they're going to, have for you, is to do an investigation to determine that they're a competent, qualified witness, that they're competent and that they're credible. Now, I know that a judge has the ultimate determination of whether a witness is competent and credible. Sure, but you're supposed to make that initial judgment as someone calling the witness anyway, so that you're not going to be relying on a witness is not qualified, because that's not fair. That's a pretty, in lay terms, that's a real douche move. So the prosecutor here has an obligation to do an investigation and know that before he puts that cop on and is going to put in there that he's relying on the cop, he has to do an investigation and know and question him and determine for himself that the witness has personal knowledge of the matters he's testifying to.
So, I mean, should I call him this week or next week, the prosecutor, to ask him this?
It's worth a shot. He the worst that he can really do there is say, I don't have to give you any discovery whatsoever until the day of trial. So just ask me on the day of trial.
Okay.
I would say, well, all right, this way you know what to bring. You don't have to give it to me now. You don't have to answer the questions, but you know what I'm asking for. So you can't, I don't want you claiming, the day of trial that, I'm surprised with this and I didn't know.
Well, I already filed a motion to dismiss, right? So he should know.
Yeah, well, he knows what your argument is, why it should be dismissed. He doesn't have an actual discovery request to respond to. Well,
I did make a discovery request as well.
Okay.
I filed both of them. Motion to dismiss and motion. There was a motion to dismiss and court stuff, Idaho. Discovery request and a motion to dismiss were filed.
Okay.
Back in August. And today I'm going to file the motion in limine. And that's filed because I haven't got my discovery, right? That's why we filed the motion in limine.
Yeah, I must not have gotten the part that it was a minor traffic that maybe I was assuming it was criminal. So the motion in limine may be a little premature. But no, then again, but you'd have to take the discovery part out of that they haven't responded to the discovery. You still have them as arguing without evidence because you've got the record in front of you and the evidence isn't there. And I just want to point out at least in the United States, all traffic, all of it is criminal. All of it. Places like Arizona, for example, use very explicit language in that some criminal traffic, because it's considered minor, are treated as civil. So if you go into the actual code in Arizona, it says treated as civil. It doesn't mean it is civil. It's treated as civil so that they can prosecute you faster and less of an expense. But when you appeal and I know this for an absolute fact in Arizona, when you appeal a civil traffic in Arizona, when you get to the appellate court, you will have a criminal number because all traffic is criminal. They've just, again, they just treat some of them as civil infractions. So anyway, I got to get to another call though. But if you can get me off air and I can get you a template for a motion to continue or do telephonic.
Okay, awesome. I'm sending you that message right now. So if you can send that to me after the show, that's great. Sorry, just to clarify, you said get rid of the part about the discovery request in the motion in limine?
Yes, because you don't need to have that in there because he's not required to give you pretrial discovery in a minor traffic. If it was a criminal traffic, then then it's right. Yeah.
Can I play dumb? Can I play dumb and be like, I'm from Canada, and they have to provide it to me before, like, the trial, so I can prepare my defense?
Well, you could just say it was an oversight. All right. The process is a little different there in Idaho. Whatever, but the motion is still legitimate in that the prosecutor is still arguing without evidence.
Okay. Awesome. Thank you, Mark. I'll send you that message right now. I'll look for that after, and I'll listen to the rest of the show. Appreciate it.
Appreciate the call. We got Mac up in Vancouver who may have to go, unfortunately, to Idaho at one of the worst possible times to drive through. So, yeah. I mean, I have family up in Idaho too, but we're not going up at this time of the year. No, I've been in Mesa far too long. And I may appreciate the rain. Oh, we got some good rain this last few weeks. We got some good rain. It was good. But it's still bright and sunny 340 something days out of the year. But I will never want to go. Yeah, not a snow kind of guy.
You have to do it just right now.
We got Lucas in Philadelphia, Mississippi. Lucas, welcome back to the show.
Hey, Mark, how you doing today?
I'm doing well. You got good news for me?
Well, I think it's good news. It's kind of 50-50. I turned in your motion that you had sent me to get turned in, and I received a call the next week. I hadn't been able to talk to you. It's been about 2 or 3 weeks ago. I got a call to go talk with the tax assessor up there to get my tag done. He told me, go see him, and we're getting everything worked out. So I went up there. I talked to him. Me and him butted heads a little bit, but after it was all said and done, now, you know a little bit about how much they try to charge, and so does the rest of you callers. I'm running around in a 2009 GMC Sierra 2500 HD. I've owned the truck for going on 4 years, and it's never had a tag on it. Now, I know all you listeners out there, and you're thinking this is fixing to get expensive. It was $38 to get my tag done.
Well, I wouldn't think
and
it was
dropped.
If that's because, and it was dropped. Oh, okay. Well, you complied. It was cheap enough, and I know a lot of it's done on the value of the truck. So, like I know here in Arizona, every year you have the automobile or the conveyance there. Every year it goes down because your car goes down in value every year. So I wouldn't think that. I thought you said it was a 2009.
Right. Well, you're correct about that. It does go down. But the way they do it around here in Mississippi, I didn't pay for it within them first 7 days, which they tried to charge me $90. I understand. I was going to buy it then. But whenever I tried to go back within them 7 days that they allow, it went from $90 to a little over $300.
Wow, you're buying.
Wow. Y'all come up with why I owe so much. And they never did. And then after my 7 days was up, it didn't change. but a garbage bill that they said I had just magically disappeared. But I tried again to get a tag a little bit later, and I owed not only the $300 and something, but then I owed late fees for the first 90 days that I didn't have a tag. Then it done been expired for a year, so I owed for that first year, plus all the late fees, and now for this tag. They don't go by, you know, just the value of the truck. They go by how long you had it without it being in their system and like that.
Well,
So it was going to cost outrageous.
yeah, you're probably just buying a week's worth of lunches for somebody, but that's crazy. Well, you know, it's unfortunate you had to pay it all, but $38 to make it go away.
Yeah.
Not too shabby.
Yeah, it was 38. What was that?
I just said it's not too shabby.
No, I think he told me it was $278 to pay the fine within the 30 days, and then after I sent that in, they contacted me back, told me go on up there and talk with them, get you tagged, and just bring us a receipt. But yep, they dropped it down and got rid of all. I don't even have the garbage bills no more. They removed me from their system.
Well, that's good. Unfortunately, you still have to pay every year, but
well, I don't have the garbage bills. I did have to pay the $38. That's why I said it was kind of 50-50. So without that paperwork, I would have probably had to have paid well over $1,000.
wow.
Because they would have probably tried to tax me with the garbage fees and all that as well. Because down here, they put your garbage bill on your vehicles, not to the address, but to the vehicle is how they collect their garbage bills.
I'm going to speak. I've got no plans to go to Mississippi anytime soon. So my heart goes out to anybody who can tolerate that place.
Oh, well, I'm looking to leave.
Wow. You know, I know
it's
there was
just hard to get the money to leave.
Hey, yeah, I understand it. You know, I mean, I'm not looking to leave Mesa, but you know, I know Mesa got a lot of hate on Reddit today. Well, a small part of Reddit. I'm not going to get into that. Well, and the police chief that I reported on.
Yes, sir. I heard
a
that.
A few months ago, who was talking about police misconduct. The police union kind of forced him out, and he resigned. So here's a police chief saying, but he's got video of cops, engaged in serious violent misconduct. And what does the union do? They move to get him out. So heaven forbid. But well, I appreciate the call.
Oh, you're welcome. I was just wanting to give you a heads up on that and tell you thank you. And I would send you some money through PayPal. I'll have to try and figure out how to get that done because PayPal don't work with my bank and like that. They had too many fraudulent cases and I just can't get it sent at the moment.
Oh,
so
that's fine.
Tips.
I appreciate the thought, and just keep in touch. Let us know what if anything else is going on.
I will. All right. Have a good night.
You too. Appreciate it. Philadelphia, Mississippi. That's Lucas, and so Paul is gotten. I noticed that Paul is saying he got out of court, and I can't seem to. Hey, Mark, I just got back from court, got the judge to say she was assuming jurisdiction. Yeah. It's all based on an assumption. I even have, again, I'm sorry, it's still the last call of shame. It's a year ago. Tax counsel for the Franchise Tax Board admitting the foundational claim is an assumption. You don't get a presumption of correctness on an assumption. It's got to be based on facts. So when the foundation of your case, by your own admission, when the literal foundation of your case that you have admitted to, and you admit that that is an assumption, that's not good. That's not good. And if we can get them to admit that, if the system was fair at all, they would look at that and say, well, counsel, you do understand there's the burden of shift does not shift to your victim here. That only shifts, as you know, if you have facts. If taken is true, see? But you have an assumption. It's not supposed to be true. So I'm glad that you got her to do that. I think it's a woman you got. Oh, yeah, she was assuming jurisdiction. Yeah, of course. Of course they got to assume it. That's all they got. Just an assumption. And then they get, I don't know why that, hopefully that's not coming out over the air. And they have their officers and counselors of the court and the people who make the money from the court system go out and make excuses. Well, it's really not the foundation of their case. It's not. It's not. It's not the foundation of the case. You're wrong on that. They all admit it. In fact, I spoke with a tax agent the other day. This is why it's important to listen to the call of shames. So if someone is seeing these things and thinking, well, maybe Marc is wrong. Maybe it's not the foundational claim. Maybe they're not. Listen to the call of shames. The tax agent I just talked about admitted that. That is the foundation of their assessment. How do I know that? That's what they tell me. And Randy is no different. I think I could take these off now. Can I take these off now? Yeah, I could take these off now. Somebody wants to get in touch. We're going to come on the show. We're going to have to do it on that their Skype at Frank Rizzo 3. And do we have anybody? No. Okay. So Randy is a deputy treasurer, county treasurer. And while there are people who disagree, sure. I don't want yes men. There are going to be people that disagree, of course. I'm not asking that everybody agrees with me. But I'm going to the source. Are all the tax agents and judges and prosecutors, are all of them wrong about what the foundational... So when I asked Scott Bales who was the Chief Justice of the Arizona Supreme Court, when I asked him about it, he didn't say, that's not true. That's not the foundational legal claim. He didn't correct me on that. He didn't turn around and say, no, that's not the foundational claim. He agreed that was the basis of their claims. And so did Randy. And now, why is this more important? Somebody just saying it on the internet doesn't mean anything. We're talking about actual cases. We're talking about actually defending ourselves against real life accusers, not getting into an internet argument. It doesn't matter what someone says on the internet. The only thing that matters is what the accuser is saying. So we take it as a skeptic. Okay, someone's making a point here. They're saying this. Marc is saying that. Let's look at the facts. Well, Marc has got the Supreme Court Chief Justice agreeing, that's what it is. He's got dozens and dozens of call of shames. He's got videos. He's got all these actual accusers. These are people making legal claims and agreeing that this is what they're doing. And Randy, the deputy treasurer, is no different. Because there's a logic and there's a rationale behind it. If you're going to tear apart somebody's argument. If you want to show that they're wrong, you have to get the argument first. You have to know and be on the same page. Because if I think the argument is one thing and they think it is another, we're not going to be able to be very effective. Oh, Paul is saying he's got to do appeal work. Well, all right, you'll have to call the show and we'll have to get that. Yeah, give me some more details. I'm kind of at the end of the show and I've got something about Epstein I need to mention. But what I'm getting to here is, and I think I've belabored the point enough now. The accuser verifies what their actual accusation or legal claim is. Once we know that, now we can start asking questions to show that they are contradictory and that has no merit. It doesn't do us any good, and I wouldn't think that anybody would say, "Why? I don't know, Mr. Tax Agent." Well, somebody on the internet said that that's not right, and and if you had gone to law school, Mr. Randy, maybe you would understand why you're so. You see, it doesn't matter because his claim is what is at issue. So even if the police officer is wrong at what the foundational claim is, and someone on the internet is actually right, when you're deciding whether the police officer has a meritorious claim, it doesn't matter what anyone else thinks. It only matters if he can prove it. It's just like one of my favorite lines from A Few Good Men. It doesn't matter what I think. It only matters what I can prove. And you can think that you're right. So this is what I was saying about this guy, Randy, and I was talking to him. So once he verified that the foundational claim is if the property is physically in, let's say, Texas, and then the laws apply. All he could do was repeat that. And I called him on that. And I said, aren't you just repeating the claim? Well, what facts do you have to prove the claim is true? And then he started saying, well, I'm not a lawyer. Do you have to be a lawyer to do your job? Do you have to be a lawyer to make these legal claims? Well, no. Then why do you need to be a lawyer to be able to verify them? So he wanted me to speak with the county attorney, and I did. And I don't have the time to get into that now. I don't have to, but this is an actual lawyer. This is someone who actually went to law school. This is the county attorney. Her name was Patricia. The county attorney agreeing that the entire assessment begins with the legal claim. Well, the property is physically in Kansas, so the Constitution applies. Well, what you would say if I was there's someone on the internet who disagrees with you, and that if you had really gone to law school, they would have taught you that that's not right. That's not the foundational claim. So I asked her a number of times, and when the last times, what really prompted her to hang up the phone, she didn't slam it down. But I asked her for the facts. Her claim was based on it. Just because the property is physically in Kansas, then the Constitution, a written instrument, applies and creates this alleged obligation. And she said, the facts are these. The property is in Kansas, and the Constitution is the Constitution. Now, I would imagine that maybe someone on the internet would think, that's rock solid. That she showed you, Mark. And if you had gone to law school, you would understand that was an answer to the question. So I just asked her, I said, aren't you just repeating the claim? We already know you think the property being physically in Kansas means the Constitution applies. Do you have any actual proof that that's true? Aren't you just repeating that? Oh my gosh. So she didn't want to talk to him anymore. And she comes out just like Randy did. When they get into trouble, they're all happy to speak to me. initially. And they say, oh, so you're working for Mr. X as his consultant. You're helping him. Okay, yeah, I'm just trying to help. I'm helping to resolve this issue. All right. There's no problem. I've not said I'm a lawyer. I have not done anything to make it sound like I'm a lawyer. I said I'm a consultant. I'm just trying to help him resolve an issue, a problem. Just saying client, that doesn't mean lawyer. Lawyers are not the only one that can say that use the word client. It's used throughout the business world. They don't have a freaking monopoly on that yet. But when she runs into trouble, wait a minute, you're not even a lawyer. What possible relevance does that have to whether you can support your claim or not? So I think I said too much to Randy. I said, Randy, you're using all the same, statements and evasions that every tax, agent at the county level I've ever spoken to says. It gets to a point where you're absolutely adamant that your claim is true, but you won't answer my questions without counsel present. So, last thing here. I don't know why the word cryptic is in here. I think it was supposed to be chilling tweet. Prince Andrew's accuser, which is also Jeffrey Epstein's accuser, writes cryptic tweet saying she's not suicidal. So a 36-year-old woman who claims she was trafficked for sex by Jeffrey Epstein posted a cryptic message on Twitter Tuesday saying that she was in no way suicidal. And there are many evil people who want her quieted. Virginia Roberts Jeffrey, one of Epstein's most outspoken accusers, has also asserted that Prince Andrew was one of the men she was forced to have sex with, and there's a picture of them. And he's not doing the hover hand. An accusation has led to his stepping down from his official royal duties. So the actual quote, I am making it publicly known that in no way, shape, or form am I suicidal. I have made this known to my therapist and GP, I guess general practitioner, a doctor. If something happens to me in the sake of my family, do not let this go away and help me to protect them. Too many evil people want to see me quieted. So that came in yesterday. So hopefully nothing happens. But we know that Epstein didn't kill himself, and if she winds up dead, she will not have killed herself. So that's that. All right, we covered a lot of ground today. If you disagree with what I presented, if you disagree with my assertion that based on the testimony, the statements from a Supreme Court justice and from dozens and dozens, if not hundreds of bureaucrats that I have spoken to, including prosecutors, actual lawyers, right? If you disagree that their assertion of jurisdiction that goes to personal and subject matter of any charge that they're making, if you're physically in Arizona, then the laws apply, the Constitution being a law, that the Constitution applies and creates jurisdiction over you and creates obligations on you. If you don't think that that's a foundational legal claim, that they're not actually making that accusation against you, that accusation does not form the foundation and creates the relevance for the other parts of their claim, give us a call, 218-632-9399. Let's hash it out. I mean, you go to the evidence, go to the source. And it's the same no matter where we happen to be. It doesn't matter if we're in the United States. It doesn't matter if we're in Canada. I have statements from attorneys in Canada. I have statements from prosecutors in Canada. I have from England, Australia, New Zealand. I've called shames from both down under there. This is not something that I'm making up. You can even see it in the documents filed by actual prosecutors. So while someone may make a claim or disagree with me, fine. That's fine. You got to look at the evidence, though. Just think, could all, or as every bureaucrat and politician that I've ever spoken to and gotten these statements from, and they verified what's basic, are they all wrong? Did they just not go to the right law school? Did they just not go to the right, schools? Are they working in the wrong? Are they all wrong? I mean, Paul Desjardins or whatever his name is up in New Hampshire. They even say the only thing the jurisdiction is proven because you're here. If you're physically in New Hampshire, the laws apply. And to turn around and say that that's not a foundational claim. We got to look at the evidence. The evidence is what is going to determine it, not someone's opinion. Not mine. I'm not asking anyone to take my opinion. I always go, you look at the facts. The facts. Look at the logic. Well, they're not teaching that in law school. That's not what that is not what a sitting Supreme Court Chief Justice confirmed. That is the official policy of the Maricopa County Attorney's Office. I have a whole video on it. I have the actual email in the article and the video. So look to the evidence. Look to the evidence. Appreciate everyone tuning into the big show today. I'm glad we were able to get back live. I will be live on Saturday, so if you weren't able to make it today, for whatever reason, we'll get you on that there Saturday show. And I appreciate everyone continuing to support the show. If you want to do so, it's markstevens.sales.com and markstevens.net. And you can also get government indicted there. And so if you want to learn how to more effectively defend yourself, not by taking my opinion, not by taking the opinion of someone on the internet, but by actually applying tried and true tactics, legal tactics, such as using the Socratic method, keeping the burden of proof where it belongs, not accepting sacred cows. You can do that at markstevens.net, including government indicted. So, again, we'll be live on Saturday. So till then, salud.